We're here today with David Rowe, Professor of Law at the University of Miami School of Law in Coral Gables, Florida. Good afternoon, Professor Rowe.
Good afternoon, sir. How are you?
I'm well, thank you. Professor Rowe, could you please comment on yesterday's developments in the Buju Banton case?
Well, it was a very unfortunate verdict for Mr. Mary and obviously for Jamaica generally. Many Jamaicans consider Mr. Mary a musical icon, and it was very disappointing for them to learn that he was found guilty by a federal jury in the Middle District of Florida, and that he is likely to go to prison as a result.
What do you think about the way the federal government went about its case?
Well, frankly, I thought that the case was straightforward and that the federal prosecutor did the professional thing. The evidence seems to suggest that Mr. Mary was in contact with a federal informant, had discussions with that informant concerning the consumption of cocaine and the sale of cocaine. He then had meetings with the informant. He then tasted cocaine that the informant showed him, and then made contact with individuals who became co-defendants, and those individuals, it appears, have pled guilty to conspiracy. So those were the facts, and I think that the facts which apparently the defense agreed to constituted the crime of conspiracy. That is an agreement to commit an illegal act, that is the distribution of cocaine.
Some have criticized the fact that the government went again after the first case resulted in a hung jury.
That is a decision that the federal government has to make for administrative purposes and for policy purposes. It should be noted that the second indictment was not the same thing as the first indictment. The second indictment superseded the first indictment and added 2 additional counts. Eventually, Mr. Meyer went to trial on conspiracy, attempt to obtain cocaine in a conspiratorial manner, the use of a firearm in a conspiracy, and the use of the federal wires to communicate with others in a conspiracy. So that was a more complicated indictment than the first indictment, and it gave the second jury more options than the first jury had. It appears that the government might have had more evidence than they presented in the first trial and the second trial. It also should be noted that a hung jury is not a resolution of a case. And so, for one reason or another, the federal government sought to resolve the case. I don't think that that is an issue for which they can be criticized.
Professor, what do you think of the quality of the defense?
David Marcus is a very good lawyer, has an excellent reputation, and is considered well by his peers. I wonder if his selection of the entrapment defense is a selection which at some later point he may consider to have been a wrong defense for this case. It must be recognized that the entrapment defense is statistically very, very unsuccessful. And generally speaking, it was very difficult for me or colleagues of mine to identify cases in which the entrapment defense had been successful in the Southern District or the Middle District of Florida. So it was a experimental defense to a certain extent, and a defense that had never been used successfully in the federal districts in this area, in a conspiracy case or in a narcotics conspiracy case. If the facts warranted, though, I suppose counsel should use the defense that he considers to be most valuable for the defendant. Again, it will be a matter of scholarship and a matter of professional controversy as to whether or not the entrapment defense ought to have been used in this case. My personal view, my personal professional view, is that the entrapment defense ought not to have been used in this case because it was a sting operation and there were never any facts that I saw which would have supported it.
Professor, thank you very much for your time.
Thank you.